So thank you for a lovely introduction. Yes, I do research, and this is our two recent research papers that we've completed through Adelaide University, looking at the biopsychosocial approach to rehabilitation or the work simulation. So I'll set the scene about the compensable setting, because that's what we're going to be talking about today. So I like to say that it's a really artificial situation where you're made to trust people very quickly about major life decisions, right? So when you get injured, you go and see this doctor that you don't know, you see this rehab person, Boris, that you don't know, you see your case managers you don't know, so you've got to trust people about your life. It's a very artificial situation, and as a result, there's a lot of personalities that come through, there's a lot of opinions, expectations, and so forth, and we manage that quite a lot of times as a result of any injury. Starts off with injury first, and then develops into something that's quite unique in a compensable setting. And we all know that people recover a lot less quicker in the compensation setting. So why do we need to determine functional capacity? So I'll just focus on more of the physical aspects today. I won't go into the vocational assessment side of things. It's quite technical and only got about 30 minutes. So by all means, just wave at me when I've got about 2 minutes left. So why do we need to determine functional capacity? So this is really a kicker slide that I always like to show. Across 13 years span from 2004 to 2016, unemployment and underemployment directly resulted in more than 3,000 Australians dying by suicide. If we put in a context, the World Trade Center is about 2,750, right? So it's a really significant toll that it takes on people. A lot of people take this for granted, but in my line of work as a rehabilitation counsellor, which is a really unique allied health profession, where we actually get trained in a tertiary career development, so we're all about employment and transition post-injury or any adversity. For us, these stats give us the goosebumps, and this is what we do. We don't want to be the ones that contribute to this stat later on. And it's an interesting paper by Professor Ian Hickey, if you wanted to ever go and read. Why do people need to know, or what do we, or people in general, need to know in order to establish capacity for work? So it's really about working person fit. You can't just do a functional capacity without vocational assessment. You can't just do a vocational assessment without a functional capacity. It's like having a surgeon who just operates, but he goes, oh, well, I'm just not going to stitch this wound. So, the surgery's done, but the consequences after that, they're massive risks. So how do we do this in our line of work? We look at skills and competencies. Do you have the technical and, for the context of this room, the soft skills, which is your core skills, interpersonal skills, people skills, employability, and all that sort of stuff? Do you have those skills the job requires? What are your interests and motivators, right? Have you ever tried to do something you don't want to do? It's not going to happen, right? The beautiful question on the IMPQ is, how satisfied you with the current job? I mean, that's a kicker to really determine where the claim's going to go and if someone's going to return back to work successfully, right? So trying to make people go into something that they don't want to, it's really going to be tough, right? So you really need to get the motivators. And as rehabilitation counsellors, all we do is that behavioural science, and how do we actually motivate people that are sometimes very difficult to motivate. Values and work styles. Does actual job match your values? It's a big thing, Who are you as a person? We call this career salience. So after injury or adversity, career salience is something that people go through stage in life and go, well, do I really need this? It's like a shock to the system, and where they start evaluating what does the career, what does the job mean for them. So scientifically, it's a really interesting concept where people go, well, I just got hurt, this is really not important to me, and I just want to move on. How do you actually motivate people to go back to work after that? So career salience is a really interesting concept that needs to be paid attention to. So what is your value? Your values shift, your goals shift. Teamwork, independence, what do you actually value at work? Quite often we see people that hurt, they just want, environment that it's safe, environment that is going to give me longevity, all those sorts of things, and sometimes you need to kind of try and readjust what that actually means. Physical and cognitive demands. I'll put that really right at the end, because it's one of those things that probably can be easily worked out. All these other bits prior to that are really challenging to get through. And I say physical and cognitive demands. Quite often when we do functional capacity testings, and we do the standardised testing, you look at the function of the person, but you actually don't look at the cognition. In a vocational assessment, you look at the cognition, but that cognition is based on little blocks and numbers that you actually get given. You know, how does a little block that kind of fits like this extrapolate to something that you'll see later on? So just want you to keep that in mind. So what are some challenges of measuring the real function? And this is, you know, back in about 2016 that we kind of thought about. My business partner, Toby Roberts, who's a neurophysio myself. There's this massive gap when we do a function capacity evaluation. A function capacity evaluation is essentially everything that you can see here. So you've got the boxes that you lift up and down, you've got some nuts and bolts that you screw here. Then we can actually take this tray out and put some of these bolts on the tray, and you just kind of bend and twist nuts and bolts, and we get you to push a sled with the various weights and step up and down. And that goes for about 3 hours, and it's a, you know, validated protocols and so forth. There's nothing wrong with it, right? However, over the years, we increasingly started seeing problems of people not being able to extrapolate from this into the real work. The reason being is someone is I don't know, a civil construction worker. They'll just go, well, where's your jackhammer, mate? If someone is a carpenter, where's your drill, mate? Where are your LVL beams that I've got to lift? Where is this, where is that? So you have this gap in people's perception around, how am I going to do that? So you go back to this experiment here. This is the cohort that we're dealing with. Wow, that's not the same. No, they're not all the same. This is way too heavier for me. You know, so it's all those sorts of things. So we thought, okay, how do we address this issue in a semi-real world situation? So we then designed WorkGain in about 2018. So the journey started about 2016, and the reason why it took us about 2 years is trying to convince councils first that it's a great idea to have consulting medical suites, to have physio rooms, to have gym in one place, and also this massive warehouse where people weld and play with trucks and all that sort of stuff. That didn't really go well. So it took us kind of 2 years, and we ended up, you know, landing, no pun intended, landing at the airport. And as Dan would know, airport is a federal land, and they're the landlord, and they didn't really care what we do. So it created a perfect opportunity for us to do this. And it is, and it has been for the last 5 to 6 years, it's been a lot of research and development. So from all businesses, like about a half of the warehouse, or the other half is on this side, and inside we've got all the white collar stuff, administration, medical, hospital, and that sort of stuff. It's been a lot of research and development, and as you'll see. So what we do at WorkGain is we actually do the biopsychosocial approach. Just looking at the function or just looking at the psychology, it doesn't really work. You've got to bring that into the biopsychosocial concept. And we've heard that as a buzzword, and biopsychosocial does not mean give everything to everybody, right? For a context, I've got 2 beautiful girls, so if I was to open up a pantry and say, go nuts for about a month and eat whatever you want, I'll be the greatest dad in the world for the first week. After that, they develop hypoglycemia, go to hospital, and don't that well, right? That's always an analogy that I use in any presentation that I give. So it's not about that, all right? It is about balancing what does the person need in a particular circumstance and what is actually reasonable to provide under those circumstances. So what do? We have physiotherapy, psychology, and rehabilitation and counselling. So straight away, we're looking at the function, we're looking at the psychology and the cognition, and we're looking at the vocational aspects. People need to know where they want to go. We've done some preliminary work with Adelaide Uni, where they looked at the spinal cord injuries, and one of the very first things when people wake up from these surgeries, it goes, oh my God, what am I going to do for the rest of my life, right? So the career development is a really crucial aspect in any injury straight from the beginning, trying to find what is the actual goal that you are rehabilitating people to, right? And a pre-injury role may not always be the answer, so try and find what is that. And like we always say, if someone comes to us and says, you know, I don't know, they're sparky and they need to install downlights, and if they say, look, I really like flying pigeons, we'll be actually getting you to throw the pigeons and fly the pigeons, because the movement is the same. Just do what you like, and then we'll worry about the rest later. And just for context, we see people that are about 15 months or 457 days post-injury. That is an average, what we deal with. So if you think about chronic being 3 months, this is super chronic, right? So the results that I'll show you are based on this cohort here. And 95% of those people, you know, that's just kind of given. have the psychological component as a secondary injury. So I'm presenting the physical cases here. So, if we look at the physical demand definition, so this is something from occupational dictionary of occupational titles that has been done decades ago, and I think last time updated in 70s from memory. But if we look at, let's not, bore you with this whole definitions here, but this is what we use to say this work is sedentary, light, medium, heavy, and very heavy work, right? At the bottom, when someone talks to you about occasional, frequent, and constant, occasional is anywhere between 0 to 33% of your day. And quite often people ask us, well, which one is it? Is it 0? Is it 1? Or is it 32 or 33? Frequent is 34 to 66. Now, it's a big chunk of your day to go. It's a big chunk from rehab. So if you ask us, can we actually rehabilitate someone back to work? Am I rehabilitating them at 1% of their day, or am I rehabilitating at 33% for this particular task? Again, straight away you're starting to see such a broad targets, and if you're dealing with people and you're trying to explain to people who, just go to work just to work, they're not experts in what we do, they're like, what do you mean by this? Right, so people like to have specific things. If we look at a medical certificate, for example, avoid heavy lifting. What does avoid mean? What does heavy mean? So go back to this experiment here. You've all scored about 13 kilos for a motor. So, half of you will go, oh, that was really heavy what I lift at work. And some people that scored the bucket, bucket is nothing. So perceptions, so if you've got a broad target of occasional from 0 to 33%, and now you've got someone to interpret what is heavy and what avoid should mean, you're already starting to see how you're getting into a bit of a trouble around things being subjective. So avoid bending and repetitive tasks. What's repetitive? How far do I actually bend? This is a bend, or that is a bend. Work within symptomatic limits. Take regular rest breaks, right? In the hands of someone who knows what they're talking about, this makes a lot of sense. We will know. But where is this certificate going? Okay? It poses a challenge, right? It creates a barrier. It's not about whether that's accurate or not accurate, it's just poor, okay? Maximum lifting, under 5 kilograms. And if we go onto the occasional definition, occasionally, so is it 33% of your 8-hour day, because that's 2.5 hours that you're going to be lifting 4.9 kilograms, or does that mean 1% of your day, which is like 8 minutes of half a gram, right? And if we look at, I've changed this up, but the context is generally the same. A paraphrased extract from a report: patients should avoid sustained forward-leaning postures, repetitive bending or lifting, and lifting objects over 10 kilograms from low position more than occasionally. So avoid. To keep away or prevent oneself from engaging in something. That's a definition. So if you say to someone to avoid, they'll go, ooh, I'm not doing it. Right. Repetitive, involving or characterized by repetition, especially when tiresome or necessary. Okay. Low position. So body postures close to the ground, such as bending, squatting, or kneeling. Which one is it? Unpredictable. So we go down, further down, it says patient is suited for light work, however, a role may occasionally involve tasks that fall into the medium physical demand category, particularly during patient transfer in an acute ward setting, which can be unpredictable. Unpredictable, not able to be able to foresee or anticipate it, subject to a sudden change or uncertainty. I don't know how this is going to go, so I should avoid it. It's recommended that the patient exercise caution during transfer and seek assistance and so forth. Exercise caution to act carefully and deliberately to avoid risk of harm. And we know what avoid means: keep away. So exercise caution. So if I'm uncertain about something, I'm going to exercise caution, which means let's not do it. So it's actually no one's fault. It's just the basic human behavioural science, really. Okay? You want to prevent yourself from doing harm, as you should. And then concern, patients should seek assistance if there is a concern about the weight. Concern means a matter that causes worry, interest or attention due to potential risk or importance. So it's about perception. So you can see things can be very ambiguous. Now for the next few slides, you're going to look at the back of my head on a bad hair day. So this is an example of a lift during a standardised assessment. Okay, so let's assume this is a 5 kilo box. It's not, it's empty. I'm lazy. Let's assume this is a 5 kilo box as well. Over here, I'm not doing anything with this arm. I'm taking all the load on this arm. So how do you test in this environment for a job that's, for example, like this, right? Or if I need to split 2.5 kilos on extremely uneven surfaces, which simulates mud or pits or whatever, this is very wobbly and very hard, so your body just goes like this continuously. How do we extrapolate this? So you can start to see where people are starting to have a bit of a warped perception about what is really my capacity, right? If we look at something like this, so we're in this position and we play with some nuts and bolts, right? So we're in a bent position and we're testing for the fine motor skills. This guy, me, is simulating, this is a real simulation at the moment that we have. So this is a person who needs to bend forward and install fire suppression systems in the mine site. I mean, this is, some nice level curvature of a spine. Dan will probably say, do not do that. Avoid. But you've got to do this for about an hour, right? This lasts 5 minutes. So you can see the difference of the two. And we talk about fine motor, these are nuts and bolts. They're about 12 gauge, 14 gauge, pretty big. How about if you need to do an IV in a tiny baby in this position, and when the hand starts shaking, very different. Or how about this beauty? When you go, okay, I'm doing a fine motor, so it's a fine motor thing. But look at that. Let's rock and roll for about 2 hours trying to undo the dashboard. So working above head. So reaching above head and working. That's not a problem, I'm reaching above head and working, but there's all this vibration that I need to drill into the concrete and carry something that's about 8 kilos for about 3 hours, right? So there's literally one job of someone where they need to put the pins into a precast concrete and they had to drill 300 holes a day. I lasted 1. And I was like, nah. So if you subject that person to this, you can see how they're going to go, how is this the same? Again, if you need to climb, yes, I can reach for the nuts and bolts, but can I actually climb on the ladder that is completely flimsy and it's pushing my body outwards from the building? This is when we talk about your first responders. Or what about if I have to just carry something that is 4 or 5 kilos with a single hand and hold it and use the nail gun to just go vibrate? How do we extrapolate from something like that? Pushing and pulling. This is a sled that we push and pull. We've all seen these wheelie bins. My left arm is not doing anything. The right one is taking all the load because it's uneven and I'm trying to turn it and it's full and people don't read what they should put in the bins and it's like a concrete and it's heavy and all that sort of stuff, right? Sack truck. Again, here, it's my right arm that's doing all the pushing and pulling. The left one is not really doing much, just holding an object. So how do we extrapolate equal distribution of weight here versus uneven distribution? Well, your beautiful first responder work, the gun belt and all the work, we're practicing at the airport now. And then pulling a patient that is about 200 kilos. Because the prerequisite is about 200 kilos down the stairs. I didn't really want to show that because I'm not skilled firing. But something like this, how is this the same to something like that? Climbing on a step, we've already seen that one, a little bit different. What about if you had to climb up on a truck with 3 points of contact? Looks pretty different to that. Or what about doing this position? Again, you can see how confusions can start arising. Here's an interesting one. So we all did this experiment and we scored what we scored. Let's say, how many kilograms of force will we probably need to push a missing pulsar? 10? I mean, let's assume 6 kilos lifting is 6 kilos of force. Let's just assume 1 to 1 minus the gravity. How many? 10, 20, 40, 50, 14. Okay, 14 to push a car. This is a hose assembly from a mine site. It only weighs 1.38 kilos, it's not about that, right? We took one washer off, so it comes with 2 washers. So you've got to join these 2 together. And this is how you do it. In between the legs, and you just twist as hard as you can. To join these 2 together, it's about 55 to 60 kilograms of force. About 50 times a day. So if I was to tell you, and this is 3 times less, so if I was to tell you to push a car for work 150 times per day, you will tell me where to go. In any language there, I know how to speak. Right? But if I was to ask you to do this 50 times for 100 grand, then yeah, it's all right. Everyone does it. Perceptions are everything. An extract from a vocational assessment. Let's move into the vocation just quickly. Aptitude. So we look at people's aptitude. Verbal reasoning, whole range of maths tests that we give them. We all love those. Numerical reasoning, we all love those. Verbal reasoning, reading, writing, spelling. I never do well in those. Numerical reasoning, sure, you know, didn't really like maths in high school. I'm never going to do well in those. And abstract reasoning, like I said, it's a 3x3 cubes that you kind of put together in like little shapes, and that's what the vocational assessment is. Now again, standardised, good, makes sense, and so forth. However, people don't see relevance of little puzzles to, you know, something like this. So if we give you, this is a real, you can see it's finished. This is what we did the other week. But we start with a drawing. If we want to test someone's cognitive and physical ability, you start with a drawing, and we don't really want to put millions of numbers that go around this and all the specs of timber and everything. And we say, can you reproduce that? So the person wanted to be a carpenter, right? From something else, I wanted to be a carpenter. Okay, can you actually reproduce this? And they were able to, but 90% of the people, no way. And here's the kicker, he scored on the lowest average in abstract reasoning. So you have a hard time explaining why did you do a vocational assessment and report on the abstract reasoning when someone can actually completely do this. So is it a work specific? You know, here's the question. So this is what we need to think moving forward. An interesting part is if we'll move on to the function now in a second. But if I was to tell you that this was, you can see there's a whole bunch of clamps here. Someone may go, why you have so many clamps around? This was actually built by a person who only has one hand. Safely, using clamps and using leverage. So if that person performed an FCE, how would you lift that box with one hand? It's pretty awkward, and how are you going to put it up the top? It's really amazing what human bodies can do. I knew you were coming. Dan Tran. So I present a case here that we referred to Dan for an opinion and assistance and help. Okay? This person was referred to us, injury to the hip, foot, lower back, all sorts of things. He was a painter, fell off the roof. Now, how can I start if I do this? No? I might do this. So if I press play, this is how the person was moving and climbing the ladders. Could not even put a pressure on one foot, so have a look at that. So when the person got referred to us, it was told, do not go back to painting. We kind of thought, I think there's a little bit more to this. And we actually asked Dan to help us out. And Dan came out a number of times to the airport to actually observe a person in real time with some tweaking and some correct feedback. And this is further walking, so this is just to illustrate to you where the person was at. So if you see someone walking like this, you'd be like, painting? Scaffold? Ladders? Yeah, it's been about 3 months and everything is going good at the moment. Full-time return to painting. Where you actually engage with an occupational physician and actually work together to problem solve rather than go, no, it's never going to happen. All right? So a driver, collision, injury to the head, a lot of vestibular issues, vertigo, POTS, hip, shoulders, lower back, ribs. It was 110K T collision, right? Through workers' comp. Day 1, we got the person to just screw some screws on a board. 3-hour session, it was what? 4, 6, 7 screws. Day 7, it was what? 20 screws. So if you think about, 13 screws per week, we're going to be here for a long run. All right? So you go, okay, practically, what do you like to do, mate? I love to assemble kitchens, but you're a truck driver. I just love assembling kitchens. So we went to IKEA or Bunnings and bought a kitchen. As you do. And we elevated work platform, make it really comfortable. Day 45, because we don't really label our boxes, right? Day 45, oh yeah mate, I can do this sort of stuff. I can lift this 12.62 kilos. And restriction was less than 1 kilo of the person to start. Where did all of this start? It started here. Because there was a purpose. Straight away he saw, okay, if I cannot be a truck driver, I can actually do inventory, stock control, and I would really like to work at Bunnings. He's working at Bunnings. Even better, day 60, he got cleared by his OT to go back into truck driving. I just wasn't really interested anymore because he found a new career path. Return work is a return to work, right? Lifetime Support Authority. Catastrophic, these are the catastrophic motor vehicle accidents, right? Accompanied with traumatic TBIs and all that sort of thing. This person was a jib rocker, and he said, there's absolutely no way I can jib rock a room like this. Like, yeah, we agree, mate. So we went and made a tiny room. But you don't go and say, oh, this is a tiny room because we think, this is how much you're worth. We say this is our soundproof booth for hearing testing, which it was for a day, right? But there's a purpose. So straight away, instead of having a big room like this, you just change the goal, chunk it, put a micro goal around it. Day 1, we just did the whole damn thing. Day 2, 3, 4, 5, the room started getting bigger. And we saw an outlet show about a year ago. We're like, hey man, what's going on? Yeah, working full-time, jib rocking, have my own business. Here's an example of someone who, again, catastrophic motor vehicle accident, got him to work on an engine. He's a young mechanic. I just want to know if I can actually do this or not. People said there's no way. I shouldn't actually be able to do this. He pulled an engine apart, put it all back together within about 2 days. And he was like, yeah, I think I can do this. Back doing apprenticeship. We tried with this individual here to work on the same engine, a young mechanic, whether I can do it or not. He could not compute that the engine was out of the car and it just didn't mean anything to him. So we went and purchased a car so that we could actually simulate this sort of stuff. Within about a week, the person's realised, nah, this is not for me, and he's moved on. So he did really well on the blocks. But it's very different to put the blocks together than have the mechanical aptitude. And again, for career development, it's actually not wrong to go, this job is not going to be for you, move on. The quicker you can make a decision, the better it is. So we always love to say, we always get an outcome 100%. It's either we're going to tell you that yes, you can do it, or no, you can't. So you at least know how to plan your life moving forward. And this is an example of someone with CRIPS. And this video has been prepared by someone doing a work simulation as a videographer, so, you know, excuse the cinematic effects. But I always love to run with it. So, person was a carpenter, or is a carpenter. There you go, he's full-time back at work. He's a carpenter, and his hands were, you know, when you get a latex glove, and you just get blow latex glove, and it just balloons, bilateral. So both hands were like that, and he goes back to me, because I'd really like to go back to carpentry. I'm generally an optimistic person, but I just went, really? Shouldn't have done that. But when you see those hands, it was just like, wow, really? So slowly, we put gel pads in the drills, anti-vibration gloves, a few other bits and pieces that we did. And we worked with a pain physician, and he said, all right, I need to go and build a roof. If I can build a roof, I can do anything. But the kicker was, so this is a forklift, and we've got a cage with a harness and everything. But the kicker was, the doctor said, yes, you can go and build a roof, but you can't climb the ladders. And I was like, oh, come on, man, really? But anyway, so lucky we have our little bucket, and he was working out of a bucket, so it's not climbing ladders in a safe, harnessed environment. And the point being is, slowly over about a 2-month period, with the greater exposure, he's completely built the roof 3 times over. Take it down, build it up. CRPS, back at work. Okay. So again, if you were to put that person through just the standardised functions, like you can just see it and you go, whoa, that's not going to happen. I thought it's not going to happen. Ask me, why did it happen? I've got no idea. It just did, right? Again, CRPS, as you can see. You can see the walking being pretty uneven, protecting the foot, don't want to even put a pressure on it. An interesting thing, it didn't want to take the shoes off when the person was with us. And I said, well, you know, when you come home, take the shoes off and show us what we're dealing with. We noticed a nice fluffy carpet, and we got, because, you know, we've got like this sort of carpet. I was like, how come the fluffy carpet? It just soothes me, it's tactile and it's comfortable. So next minute, we made it super fluffy and super comfortable, right? Took off the shoes, working the socks, so walking up and down and so forth. And these were the very first steps that the person took for a while. That was pretty quick, and the person was moving like this initially, right? You can't hear it. In the background, we had AC/DC blaring, because she told us in a conversation that the favourite band was AC/DC. So we had that nicely kind of in the background there. Nothing much to it, but it actually distracted her from the long limbs. Fast forward about 2 months. This is a person walking on extremely uneven surfaces, and is working as a support worker, supporting others now. So very quickly, how am I going with time?
No, I didn't.
All right, okay.
Sorry.
I'll wrap it up. So
I was interested.
thinking about the 15 months post-injury data, so this is based on probably about 100, 120 people, right? So we look at the data after about six weeks. We ask people, what's your confidence like? Average 60%. So it's really, the confidence intervals are pretty tight as well. So let's say after about 6 weeks, their confidence significantly increases. This is part of another paper that we're working with Adelaide Uni. Their fear reduces significantly by about 60%. Reduced avoidance, increases in strength, their perceived work capacity, their endurance increases, psychological wellness significantly increases, lifting ability, range of motion and so forth, functionability and their perceived work readiness. Pain does not change at all. No signs to it. It actually probably most times it actually gets a little bit worse. But All those people that are part of this study are back at work, or retraining, or signed off for their job. All of them. So it's not really trying to measure the pain aspect, it's actually what you do with it functionally. And this is the biopsychosocial aspect that we talk about that we published with Adelaide Uni. So this is just a comparison between the two. You don't need to read into that. But thank you very much. I hope this was interesting talk for you, and I'll open up for any questions if that's what it is.
Got a question here. Might just start with Jenny.
I'm pretty loud, I know that I need more. Hi, thanks for that, that was pretty awesome.
No worries.
I was just wondering, in the slide where you've got the broad targets, part 1, you've got the occasional, frequent and constant lifting, that's been defined. How has that average been taken? Has it been taken over the whole shift? Because then what happens if, say, someone does lifting at the beginning or at the end, but then not in other parts of the shift? Am I thinking about that too much?
Yeah, so it's been divided by 8 hours. So they look at the 8-hour working day. So great question. So what happens with the mining industry when it's 12 hours a day?
Yeah.
Or what happens with someone works in a servo? So servo is generally a light work for 95% of your day. But when the delivery of coke and milk and everything comes, you've got about 15 minutes to unload 2 pallets. It's extremely hard. So it doesn't capture that. It just shows you over an 8-hour day. So there's a software that we've been working on that we've developed that actually looks at the instantaneous force while you're doing that task, because that, we believe, is a true measure of someone's body loads in that particular point.
So as you all know, being in this industry, we've had some recent changes to Section 18 of the Act, which is likely to affect some of you more than others, but essentially it's a big expansion. So previously we had the onus of showing that it wasn't reasonably practicable to provide an injured worker with suitable alternative duties. It seems like that's not going to be enough anymore. We're going to have to look at it in a wider way. Even now, there's not a lot of law, as we know, on what that means. But it's going to be interesting to see what happens in terms of this expansion. The business needs is not something that is going to be taken into account, I don't think. It's going to be very worker-centric, which of course is the idea of the whole piece of legislation. Boris's whole talk really makes us focus the mind, I think, on Return to Work Act being the name of the piece of legislation. So obviously we all know that Section 18 requires an employer to provide suitable employment, and that's going to be when the work has any capacity at all. It's pretty obvious, and it's always been this way, that the bigger your organisation is, the more likely that's going to be something that is required of you. So if you've got a small bakery business and you employ 20 people, it's much less likely that the court is going to find that you need to find something for someone who's got 2 hours with no lifting, a week. The difficulty for me is, especially given that I do a lot of industrial law, is that it's completely at odds with other pieces of legislation. Sometimes you might argue that a Commonwealth piece of legislation trumps a state piece of legislation, but it really depends on the facts of the case. So it's really difficult to know if somebody's injured, whether or not it's in your interests and in their interests to try and find something for them to do, or whether that's just going to cause them more distress or exacerbate any physical injury. But you have to weigh up the risks as between that and whether or not you might find yourself being sued in another jurisdiction. There's not going to be any time limitation except for these few... my brain went stupid then. Except for these few exceptions. First of all, that it's not reasonably practical to provide suitable employment. That's always been the case. As I said, the onus is on you to prove that. What that means is going to be different in every situation. The worker left his or her job before becoming incapacitated. I think there is still potential there for that to be re-established, as people try to do with breaches of mutuality. Again, that's the same if the worker resigns, or if alternative employment options have been agreed between the worker, the employer and the Return to Work Corporation. Does anybody have that happen easily and quickly, where all three have a happy time agreeing? I can't see it happening very often, but anyway. Or if the worker's already returned to work with the pre-injury employer or with another employer. That one will be very fascinating, because there's oftentimes circumstances where somebody leaves and then comes back to work at their injury employer. So that one will be interesting in terms of interpretation. Sorry, excuse me a minute. So there'll be no restriction on the employer's statutory obligation to provide suitable employment. A worker could remain employed with their pre-injury employer, performing suitable duties in an alternative role for many years following the date of the injury, which can be a really significant cost to a business. There has to be some ongoing certification that there needs the injured worker to be provided with alternative duties. We don't know how detailed that will need to be. Do we have people like Boris or Dr Tran coming to the workplaces and doing much more detailed reporting? And the other thing that occurred to me, for those of you who have been around as long as I have, this sounds to me very much like the old Section 39 in the Rehabilitation Compensation Act, where we spent an awful lot of time trying to identify jobs that somebody could do outside of their own job. So whether that will happen, and also surveillance. Are we going to be seeing a spike again in surveillance, which was reduced, I think, after we reduced the entitlement period to 2 years? They went, we'll just let it ride out, it's only 2 years. So if somebody's entitled to have a job that an organisation can't really afford forever, do we then start filming them playing cricket on the weekend, Remains to be seen. So what if a worker who's been certified unfit for work and receipt of income maintenance payments for the maximum period decides to seek suitable employment with their employer once those payments cease? I think that's something that will really get up the nose of employers as well, that while they're getting payments, they can't do anything. The minute that their payments cease, amazing, we've got some capacity now. That's also a risk for businesses, because they come back to work and potentially they re-injure themselves. Very interesting in the light of Boris's presentation this morning, because he would have us believe that we can assist people to return to work. Unfortunately, not everybody is able to use your services. It would be good if there were more of you around. Look, these are, pretty common sense, things that need to be weighed up when we're returning somebody to work, because we have an obligation to do so. It's a matter of weighing up what's safe, what's practical for the business, what duties are actually available. I mean, it's very dependent on the kind of industry you're in. The risks are different. I mean, if you're returning someone to work in a mechanical workshop, really the risk is probably to them. If you're returning to somebody to work in a medical or aged care kind of situation, the risks are also to your clients or those sorts of people. So it's something that you're going to have to take on a as needs basis, I think. So what will constitute suitable employment? I mean, it's been set out in the legislation, but I think this is something that's going to have to be the subject of some decisions. The workers' place of residence is a pretty hot one for a lot of workers. Is an hour-long drive reasonable? Is a 10-minute drive reasonable? I mean, sometimes people don't have organisations that are necessarily very close to each other. I mean, in South Australia, where we're set up, leaving aside regional areas, a lot of people have a north, a south, and a central kind of office situation. So if somebody's working in the north and there's only duties available in the south, is that unreasonable? I mean, I think about time spent in London, an hour on the train is nothing for people there. So that these are all sorts of considerations that will have to fall on the facts of each case. We do have a couple of decisions that obviously are not under this new interpretation of Section 18, but essentially both of these say that Coleman sleep is a physical injury and Roberts is a psychological injury, and they both say that if the person has ceased to be incapacitated, then Section 18 doesn't apply. Rossi has made it very clear, and he likes to tell me all the time when I see him about these sorts of matters, that if the person has ceased to be incapacitated, then Section 18 is not the appropriate mechanism. You need to deal with it through contract law or through the Fair Work Commission. A lot of people don't want to deal with it through the Fair Work Commission or contract law because of the cost provisions, whereas here in the tribunal, it's something that can be paid for and the workers' lawyers can get their costs paid. So it's a lot less of a risk.
Sorry, the cease to be incapacity is totally different though to a full clearance. That's something you have to seek separately from their doctor.
Yeah, definitely. So just as a little snapshot of what we know so far, of what the amendments have done for us, is that obviously the duty to provide suitable alternative employment continues after recovery. There's a potential for back pay orders against the employer, so if you don't offer suitable alternative duties for a period of time and a court finds that you ought to have done so, then the court can order that you pay the worker arrears. There's an obligation on the labour hire organisations that they are also involved in providing suitable alternative duties for injured workers. It hasn't gone so far as to say that the labour hire organisation has to have the person as an employee, but they do have to assist in the placement of the person. And as we know, the obligation of the self-insured employers is that it'll be across the entire group. So it won't be enough to say we don't have a job for you to do here. You will have to look at other areas. That's really, really difficult, I think, and I think really unfair, because the onus is on people like you to liaise with other people who don't want this injured worker either, to be able to place them somewhere. It's pretty hard to be selling, a candidate for another role if you know that there are significant issues, whether physically or psychologically, that you're, essentially dumping on somebody else. And there's lots of interesting arrangements in the corporations law around that might have to be fleshed out in the tribunal as well, I think, in the way that organisations are set up. And I will hand over to Chrissy at this point. We're going to do a little bit of a case study later, which is a real life story. So I'll try and be as interesting as Boris, but I'll hand over to Chrissy for now.
Okay, so just pragmatically flowing on from what Claire has identified. Supporting evidence. So what do we want to see versus what we actually see? So we're supposed to get written requests which include the famous words, confirmation that someone is ready, willing and able to return to work with the employer, and details of the type of employment that they consider they are able to perform. Now we know that that's where our frustrations always start, because you get a very generic job description, or effectively I can do my old job. That's not effectively what the legislation is designed to capture. We want to see some detail, and you want to essentially see some medical evidence supporting the fact that they have capacity for work. So we always get a WCC as a bare minimum, I think, but ideally, particularly if you've not seen this person for 4-5 years, or as Claire indicated, for the entire 104 weeks, they've been unfit for work and all of a sudden they do regain capacity, then just a bare bones work capacity certificate with some minor restrictions, avoid lifting, etc. Although I've got a very different view to that now, thanks to Boris. You do want to see something a bit more substantive to be able to identify what it is that people can perform. Capacity for work. So we know that the tribunal has held that Section 18 of the Act only applied to workers who had a current incapacity for work. The amendments do mean, as Claire indicated, that it also applies to a worker who has ceased to be incapacitated for work as a result of the work injury, but we have to receive a notice of their request within 6 months of that cessation of incapacity. All right. Our responses. So we get the bare bones letter which says, "Hi, you've not seen me for 5 years, but I'm now ready, willing and able. And here's my work capacity certificate which says that I can do my old role, or I can be a machine operator, a cashier, etc." What do we do with that? Now, on the face of it, we all go into panic mode, me included, and you start frantically thinking about what evidence we're going to need. What we have to get better at is responding to outline where the deficiencies in that, I'll call it application or that letter, requesting suitable employment, as quickly as possible in our response. So to say, thanks very much, the WCC doesn't give us enough information, we're proposing to organise an independent medical examination, we need a functional capacity evaluation. Things like that we're going to put into place. We may need, of course, to get the GP's certification to say that someone can do the FCE. All of those things which take time, but also take us outside of the 1 month that we have formally to respond to someone's request. So we're happy to consider your request for suitable employment. Here are the things that we need you to undertake, or we need to do working with you to establish what your capacity for work is before we can make a decision as to whether or not it's reasonable for you to come back into the workplace. If we flat out refuse to provide suitable employment, or the worker considers that any employment offered by the pre-injury employer is not suitable, then as you know, within that 1 month of the refusal or offer of unsuitable employment, they'll apply to the tribunal with their application for suitable employment. Serious and willful misconduct. So the bar and the onus on us is the same as maintaining that discontinuance or defending the discontinuance in the first instance. So Section 18 will have no application if the worker's employment was terminated on account of serious and willful misconduct. However, of course, we bear the onus, as I said, of establishing that. Under the amended Act, it's not clear whether performance issues would be sufficient to defend a Section 18 claim. But what we do think is that the existence of those performance issues, at least in some cases, would provide for a sufficient basis for an employer to argue that it's not reasonably practicable for suitable employment to be provided. All right, I see nodding, so everyone follows, that's good.
Chrissy, do you think that will apply across multiple employers in the self-insured group? So there's argy-bargy performance issues with one particular employer, but do you think we'd be able to use that defence against other employing entities within the self-insured group in terms of whether it's reasonable to provide them with work?
Look, I think if you're comparing like for like, absolutely, yes. Well, ideally, that's how it should work. That's how we would like to see it work.
I think it's also an industrial, I think it's also an industrial issue that if somebody's on a performance plan or something like that, just because they have a workplace injury doesn't mean that they're excluded from that performance management. I don't know where it comes from, but loads and loads of people, lawyers included, think that if somebody's on a work cover claim that you can't deal with them industrially, and you can, and you should. So if somebody's, on a PIP, for example, they have a back injury, and then they want to come back to work and make an application under Section 18, I think that's something that needs to be raised, and usually you would say that still applies. I mean, they can't have it both ways. They can't say these rules go across the whole group and then say, oh, apart from this bit, we'll quarantine that bit because that doesn't serve the worker. I think, anyway.
Is there any direction on who pay for the cost? Is it the insurer or the employer paying for this service?
Sorry, what services are you?
So an injured worker finished a claim,
Yes.
or at the end of the claim, certified fit to go back to work. It is recommended that they need an SCE and a medical in. Is that an insurance cost or is that an employer's cost? Is there any direction on who paid for that?
The employer, being a self-insured employer,
Right.
will pay for that. The insurer generally, yes, will pay for that.
But if it's a registered, I think that's the issue. And a lot of times, registered employers get an application and they have very little information about the medical status or functional capacity of the worker, because that's all been done by EML.
That's right.
Or Gallagher Bassett, and it's particularly difficult getting that information because they often don't receive it. And if there's a lack of information at that point as to what is the worker's actual capacity, who is then liable to pay for it, I think in that situation, unfortunately, the registered employer ends up having to foot the bill to get the information themselves, unless it's already been done by the claims agent. It's a problem I see all the time for registered employers. I mean, self-insureds, they're going to foot that bill anyway, but for registered, it's very tricky as to what information they get given and what information they actually need when faced with a Section 18 application, which is often, as Dr Traynor said, at the end of the claim, like the entitlement period's finished and this worker has still not gotten back to work or found other employment. So the easy option is, I'll go back to my pre-injury employer, and then that employer's like, well, I haven't seen you for all this time, and you know, every now and again I got an update from Gallagher Bassett, but that's about it. So I think they end up probably having to wear it themselves. But it is a real problem.
And because of the time frame that we have prescribed in terms of responding. So you will find Tracy's right. The registered employer will pay because we've got to get on with it and we need the information. So that's the difficulties we face there pragmatically. Powers of the tribunal, we know that they will now have the power to make orders which specify specifically the duties that are to be provided. Any adjustments that we will need to make to allow the worker to perform specified duties and the number of hours of work that employers must provide to the worker. So that's the scary part in allowing someone else to make that decision ultimately for you as an employer. Payment of wages, they will have the power to require an employer to pay a worker the wages or salary that they would have expected to receive in the suitable employment if it had been provided from the date they made their request, even where a worker is outside of their entitlement period for weekly payments. We all know how slowly things can move at the tribunal. This could result ultimately in a significant back pay or lump sum payable to a worker and significant financial implication for an employer. There might be concern that a worker is double dipping if they have already received compensation for their economic loss. Again, that is something that we're going to have to deal with and see what the tribunal does with things like that. Who does it impact the most at the moment? Obviously, yes, for registered employers, but groups of self-insured employers, many of you in the room, agencies and instrumentalities of the Crown. Duty of an employer to provide suitable employment where that employer is part of a group of self-insured employers, an agency or instrumentality of the Crown now extends to other employers within the group and other agencies of the Crown. That's the big unknown, insofar as we're not quite sure how the tribunal is going to deal with that. The duty is no longer limited to the pre-injury employer. Other employers, agencies, instrumentalities should only be considered if there are good reasons for employment to be provided by another member, agency or instrumentality. So retail, for example, is always a good example to illustrate. Someone working, for example, office works, that's the first thing that pops into my head. Where can we place that worker within the umbrella of the self-insured employer, for example, in other retail outlets? It doesn't necessarily just mean that we're limited now as we were, or as we like to think we were formerly, insofar as we were certainly not testing that boundary. The amendments will only apply to groups which are related bodies corporate, and so presumably they would share a management structure which would make the movement of the worker from one employer to another a coordinated process. Again, will be interesting to see how the tribunal deals with the legalities of enforcing a separate entity into an employment relationship with someone who is not their employee. All of those concerns can go directly to Claire. There will also be issues of retraining and vocational suitability, one would think, that we have to take into consideration. So someone's skill set, we'll always need to look at that very closely. At the moment, no explanation of what a good reason would be for requiring a different employer to provide employment. But we can all think of good reasons, and it'll just be interesting to see what the presiding members label that to mean or not to mean. Costs. The amended Act now specifies that employers who are not the compensating authority have the ability to claim costs from the compensating authority for their involvement in a Section 18 dispute. Of course, they're the regulated sums, regardless of the outcome of the dispute, provided that the employer has not acted unreasonably or vexatiously in the course of the proceedings. Previously, we know that the employer was only able to claim their costs if the tribunal declined to make an order that the employer provide the worker with suitable employment. All right, that all makes sense. Labour hire, now protected under the amendments of the Return to Work Act. Well, sorry, they were, but more specifically, there will now be an obligation on host employers to cooperate with the pre-injury employer in offering suitable employment. The amended Act does not create any obligation on the host employer to directly employ the labour hire worker. They will remain an employee of their pre-injury employer. Cessation of our obligations. The Act still doesn't address when employers' obligation to offer suitable employment comes to an end. Seriously injured workers have no entitlement to weekly payments past retirement age unless their injury occurred less than 104 weeks before they reached retirement age, or it occurred after they reached retirement age. I hope that makes sense. We can follow that, yep. An employer's obligation to offer suitable employment is ongoing past retirement age and does not come to an end. Arguably, the obligation never disappears unless the exclusionary factors set out in 18 subsection 2 of the Act apply. Okay. Any questions before we look at a real life case study? Sorry, there's a bit of interference. I'm not sure where that's coming from. No? I will pass back to Claire.
Chrissy and I were going to make this a bit of an interactive session, but we're running a bit behind time and we want to get on to IAGs. But this is actually a case that I have at the moment. I've changed it a little bit so that in case somebody knows who it is. But this is somebody who's made an application to the court. Rossi oversaw it at JSC the other day and was quite... he gave the work a short shrift, essentially. So he worked for a state government department, essentially in an administrative role, and applied for a job that was on the internal, government gazette thing to apply to anybody could apply. It said open to everybody as a wildlife keeper within this organisation. Now, I love me cuddling a koala like the next person, but I don't think that's what it was. The client told me that there was significant training that was involved in this, and you would presumably think that if somebody was making this application for something quite out of the box, considering her skills and expertise, that there would be some onus on her to prove that that's something that she could do, rather than just visions, as I said, of cuddling a koala. Anyway, that was the application that was made, quite seriously. And in this situation, Rossi did say, look, that's, you have to be a hell of a lot more specific about your application. And then she raised another role completely out of the blue, which was the first time that I'd heard it at the JSC. So I think that if Rossi's anything to go on, there will be a requirement that there is some very detailed analysis of what a new role or a role applied, that's the right word, under Section 18 will entail. So, does anyone have any questions about that? If we know the answers, we might know the answers in a year or two, or maybe not for 10 years, like we don't know now from the previous Section 18. No? All right. Well, I will ask Tracy and Lauren to come up. Are you doing a little spiel?
So the revised IAG's Impairment Assessment Guidelines are taking effect as from 1st October 2025. They've made it actually pretty simple for us to all understand which guidelines apply to what claims. Any assessment for any claim after 1st October is under the new guidelines, except for someone who has already started their assessment. So if you've got a worker who's got multiple impairments and having more than one assessment because different assessors have to assess the various different body parts being claimed, and one of the assessments has already occurred, then they remain under the current guidelines. Anybody else starting after 1st October will be under the new guidelines. It doesn't matter when the date of injury is. So it's actually, for once, quite simple to work out. So that's the first thing. Now, we're not going to be talking about achieving maximum medical improvement anymore. We're going to be talking about stabilised. This is as a result of the amendments that occurred in December 2024 with the Return to Work, Employment and Progressive Injuries Amendment Act. Not a lot of deal of difference between MMI and stabilising, but it was actually brought in specifically to address the problem of people with terminal conditions. I do a lot of work in the dust space. The issue for those types of claims is they may never stabilise, or no, they may never achieve maximum medical improvement because they're continually progressing. So it was actually designed specifically for those conditions, but as a result, we now refer to stabilise. Basically, stabilise implies a condition is not likely to fluctuate in the foreseeable future, although temporary fluctuations can still occur. Right. So, there are a number of material changes to the process in general. These are all in the first chapter. If an assessor identifies an impairment caused by a medical condition that is not referred to in the assessment request, or the assessor is not accredited for assessment of that injury, they must contact the requestor to discuss the issue. If they can't make contact on the day, they are to do the best they can by basically taking as much of the history of the condition as possible, but they can't proceed with the WPI calculation. So the remainder of the assessment must be deferred. But as I said, they have to try and complete as much as they can. There are similar, sorry, I'm having to use my laptop because I didn't have time to go to the office and get my actual paper. And I'm such a nerd that I can't even do this properly. There we go. I hate laptops. I really do. I like to have my keyboard, my screen, my mouse. Similar considerations apply under clause 121. If the assessor concludes the injury is not stabilised or they think further tests or investigations are needed, they should contact the requestor and discuss what is required. But if they are dealing with a worker from a regional area, they are required to try and finish the assessment as best they can to avoid inconvenience. You don't want to send a worker away from Mount Gambier because you've decided, I think they need an MRI first before I can complete my assessment. So they should really do the best they can with that, and if necessary, then speak to the requestor, get authority to proceed with whatever the investigation is that they need, which would then presumably be sent to them in order for them to complete their assessments. So for regional workers, they are required to do the best they can. If we have multiple impairments, and we see them so much these days, people start off with a back injury and then their gait issue occurs, and then they've been taking too much anti-inflammatory, so they've got their stomach problems, and they've been grinding their teeth because of their psychological issues, and now we've got the dental. So we've got multiple impairments being claimed. They still have to look at the deductions in the same way. They still have to incorporate the combination in the same way. None of that has changed. So basically, Summerfield still applies under IAG 3, and in fact is now incorporated into the Act. So the combination issues have not changed. And requesters are to use their best endeavours to obtain all relevant information for the assessor. So it's our job to try and give them as much as we can in order for them to
do their assessment. It can be quite difficult, particularly with medical notes. I mean, there are certain practices that will simply not provide medical notes in the absence of a summons. You can't get a summons if you're not in dispute. So, you know, even if with a worker authorising, there are certain practices that won't give them. So, but, you know, we are encouraged to do as best we can to get the relevant information. Choice of assessor, not a lot of changes. The worker still gets to select their assessor, so the process of nomination hasn't changed. However, if there are multiple assessments, then they are required to nominate the assessor who can do the most body parts. So they're trying to restrict, you know, having some, I mean, I get regular requests that require at least 3 assessors to do the assessments. But there are some assessors who are accredited, obviously, in more than one body part, and they are required to nominate the assessors who can do the most. We now have to provide the draft report request at least 20 business days prior to the assessment, so that is definitely a change. And we have to provide the information to the assessor at least 10 days prior to the assessment. Often can be difficult when you're still trying to get information, but you know, that's what we're required to do. And we now have clauses 14 to 50 that give guidance regarding specific conditions, including timeframes as to when certain conditions can be assessed. So there are restrictions on...
I've got a question for you.
Well, don't ask me about which ones, because I don't know.
Dot point number 2 regarding the multiple assessments.
Yep.
What if you get someone who, for example, like Dr. Siapto, Dr. Dionisi, they are extremely popular, and you can't get, you know, an appointment, say, until, let's just say, January next year because everybody's choosing them. Can 2 different assessors then be nominated?
You need to. You can go back to the worker or their solicitor and discuss those issues as to the length of time with a number of the doctors who are always nominated. But at the moment, you know, it's kind of working in your favour to have it stay out as long as possible, because it gives you the time to actually get the information you need, particularly if you're trying to. Particularly if you've got like multiple body parts or multiple injuries. We get a lot of requests with people who've had, you know, a whole series of injuries over the length of their working career, and they suddenly want everything assessed right at the end, and you've got to go back and try and reinvent the wheel. It gives you enough time often to get all that information. So,
or if you don't want them to be assessed until after October.
well, no one can be assessed now. If they haven't booked in now, you're not getting assessed before the 1st of October. By anyone, doesn't matter who you nominate, because you're not getting an appointment. And in fact, I went to an ENT. Yeah, I went to an ENT training session the other night specifically on the changes for hearing loss and facial injuries. And Return to Work SA actually stood up to the group of ENTs there and said, "Can you give us more appointments? We are so desperate. We need more appointments." And all the doctors are like, da, 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 da. Like, well, we're swapped now. What are you talking about? So,
It's alright, just get your PA to write the report.
yeah, well, that's what PIA used to do. So, they're also actually in those clauses 14 to 15, not just the guidance on the time frames. But now there are certain conditions that can only be assessed by certain doctors. For example, sleep apnea can only be assessed by someone who's got qualifications as a respiratory or sleep physician or an ENT. Hearing loss assessments must be in person, no telehealth anymore. Mastication and deglutition, so these are our dental claims, must have prior dental records, if they exist, of course. Some people don't actually go to a dentist. There must be a report from the treating dentist and a dental x-ray that's been taken in the 12 months prior to the assessment. So that's a significant change. If you've got an unusual condition resulting in urinary impairment, they must have had appropriate treatment options advised by a urologist or gynaecologist. So there are some significant changes in respect to some of the more unusual claims, but we are getting so many more of these claims. It's consistent with the rise in all the consequential claims that we've got before and post Summerfield. Get this to work, we'll be doing well, here we go. Just some specific changes. Chapter 2, upper extremity, obviously arm. Peripheral nerve injuries can't be assessed unless the symptoms have been in place for 12 months. Adhesive capsulitis can't be assessed for at least 18 months. As we know, adhesive capsulitis can resolve all on its own, so it's obviously giving it a longer time frame before a worker can say, I want my condition assessed. Major changes for CRPS. The assessors have to have specific training. Condition must be present for at least 18 months and have stabilised. There is a lower threshold for the diagnosis. So previously you had to have 4 and 4 signs in each category. Sorry, each category had to have the sign present. Now it's only 3 out of 4, but the ratings are lower. So before, pretty much if you got through the gate on CRPS, you were seriously injured because the classes percentages were so high. There is now a lower rating. So the class 1, for example, is, I just had it up on my screen. So it's up to it's up to 29% rather than, and so as we know, 35% is your threshold. So if you're in class 1, for CRPS, you were not going to be seriously injured. Before, pretty much, if you got through the gate with CRPS, you were considered seriously injured. So have a look at that. And so there are major changes about CRPS.
Is the class 1 equivalent to type 1? Or?
It applies to both type 1 and type 2. Oh. Whereas before in the current... Thank you for asking that question, Jeannie, because I only looked at that last night. Although I better go back and have a look at these CRPS changes. These changes apply to type 1 and type 2, whereas under the current IAGs, there's a split between how you assess type 1 and how you assess type 2. They're both assessed under the same principles now. Gee, I'm really glad I looked at that. Chapter 3, lower limb. The main change is the new assessment for rating joint replacement. So we used, for a total knee replacement, we had one good outcome, fair outcome, poor outcome. Poor outcome was automatically 30%. Now we have a very poor class, which is 35%. So we have now good, fair, poor and very poor. So only someone with a very poor outcome from a total knee replacement will reach the seriously injured threshold. No real changes for spinal conditions. And my favourite topic of all, of course, is hearing, and I'm only going to do it very quickly because Lauren is going to do a case study, which will hopefully, and she's going to have to be real quick because we want to try and get you out of here vaguely on time. Must be in person, no telehealth, can only be done by an ENT. The assessor can request serotesting, cortical evoked response auditory, which is a much more objective testing, so if there's inconsistencies in the testing, they can request that. They must provide clearer identifications of any non-work related impairments. There are rules now about what they use in terms of air and bone conduction thresholds above 2,000 Hz. Major changes for assessment of tinnitus. You only now get rated for tinnitus if it's actually classified as severe. Mild or moderate tinnitus does not rate at all. Prior audiograms, if the worker has retired, the assessor is directed to look at the audiogram or audiograms closest to the date of retirement rather than their assessment on the day. So if you are aware your worker has retired, I would recommend that you direct the assessor to that point and do your very best to get whatever audiograms exist, because we know that often when we're getting these claims that people have been seeing the audiologists for years. So there'll be a whole heap of records that you should now start to get because they should have much earlier audiograms closer to the date of retirement. There is a case on that, but it was more a discretion, so now it's a direction. There is clear methodology for doctors, including losses below 2,000 Hz, so 1,500 Hz and below. So they have to provide a much more greater rationale to do so. And there are also threshold limits at each frequency. So before, if you had lost, say, 100 decibels at a certain frequency, that was included, that frequency will be capped now. So potentially the assessments could be lower because there is a capping on each of the frequencies. So they have made some significant changes about the way hearing loss is assessed. Any quick questions? Otherwise, we'll just keep it moving and get straight into Lauren so that we can hopefully get you all out relatively on time. I'd like to introduce Lauren. I'll get rid of it. I think you've got your clicker.
So yeah, we've heard all about the changes from Tracy, but what does this actually look like when it comes to assessments in hearing in particular? So I've just got a bit of a case study. I'll get rid of all the jargon and we'll get onto it. So let's picture a worker being assessed under the current IAGs. An assessor typically goes through the history of the worker, and as an introduction to their assessment, John Smith is a 70-year-old retired worker. He has noticed hearing loss in the last 11 years and has claimed that he has no non-work-related noise exposure, no familial hearing loss. So just from these facts alone, very simple, there's actually going to be changes. Retirement originally did not flag any obligation for assessors when assessing a retired worker. Now, when assessing a retired worker who has retired on account of age or ill health, the new guidelines require the assessor to consider any audiograms that have taken after ceasing work and prior to the assessment. So to better determine any non-work related components of the current impairment and also potentially assess the PIA at an earlier date rather than the assessor using the results of the audiogram that they take on the day of the assessment. So if John had been seeing Audica for the last 5 years after having audiograms during those visits, rather than using the audiogram on the day, the assessors can now adopt the results that have been applied at a date much closer to retirement and potentially last exposure to noise, achieving a lower BHI, and then including all non-work related losses that may occur after retirement. At the moment, generally assessors will use the audiogram taken on the day and only deductions that are likely to be age related. So what we must do as lawyers and compensating authorities when requesting a PIA is ensure that we have directed the assessor to the fact that the worker has retired on account of age or ill health in our requesting letters. We'll also make sure to obtain the relevant records from the hearing aid providers that may contain audiograms taken closer to the day of retirement. So John Smith also reports that he's suffering from, and I always pronounce this wrong, so Tracy, tinnitus. Tinnitus. I said tinnitus for about my whole life until I started this job. His tinnitus is rated from mild to, at worst, moderate. The reports tend to go through some history of hearing loss and tinnitus and the impact of the worker's life, what they're facing. So before, John's assessor would clinically use their clinical judgment and experience in their field to consider examples of tinnitus, and the impact that it had on the workers' activities of daily living. Before the changes, they just used their judgment to provide a percentage. In this case, the assessor said that beforehand said that 3% bilateral hearing would be appropriate for John's tinnitus. Now, post changes, it would be classified as mild, moderate or severe. Mild and moderate tinnitus is simply not rateable, so therefore attracts 0%. If the tinnitus is judged to be severe, the assessor then needs to document the impact of the tinnitus when referring to the ADLs, the activities of daily living, and there needs to be a clear rationale that supports this value that they have assigned. So the new guidelines provide for an assessment of up to 5% for severe tinnitus. So if John's assessor can document and support that this tinnitus is severe and worth 5%, but really 5% is worst case scenario, so we are now potentially looking at a lot lower assessments. John's audiogram are inconsistent with the reported history of noise exposure. So after Chapter 9, an assessor has the ability to request a cortical evoked response audiometry, or a CRA, to be undertaken. Any rationale for this test being potentially required will need to be included in the assessment report. This just gives a more objective testing outcome for the assessors. In the evaluation of hearing impairment, there is typically outlined in the PIA is where the assessor would start talking about MMI, which Tracy has described now as, or is described now as, stabilisation. Although this should have been dealt with before a PIA, hearing loss results from loud noise exposure, as we know, and cannot be returned after, regardless of treatment. So the same concept applies post changes. There's also been changes in respect to whether the assessor has used air or bone conduction thresholds. And as Tracy mentioned, there's also a cap. So 500 Hertz to 4000 Hertz has a capped maximum rating that applies. This could mean that John's actual loss at the relevant frequencies can be capped. So it's not in the example I'm about to show you, but if I can get this pointer, if we're looking at 2000 Hertz, John's loss is capped at 65. So even if his actual loss is 75, so even if it was sort of sitting down here, it's capped, so that will obviously reduce the BHI and resulting WPI. So looking at the audiogram presented on the screen, we see that the left and right NIHL for 500 Hertz and 1000 Hertz are in the mild range. The decibel loss would have originally been found to be 25 each ear, so not quite enough to get any BHI. However, as we look across the audiogram, there's more decibel hearing losses in each ear. Originally, this audiogram would have been found at 3000 Hertz to equate to a 50 decibel loss and a BHI percentage of 4.9. So yeah, there was no cap previously, but it would be capped if this example was a little bit higher. Overall for John, originally under the Schedule 2, a WPI would have sat around 9%, but from my rough calculations, although I am not a doctor in any capacity, my WPI is more likely to sit around 5%. Therefore, it is possible you'll see some low impairment changes, which will reflect positively in terms of your future liabilities for these types of claims. So just quickly in a nutshell, these changes tightens definitions, reporting formats and assessment criteria. There appears to be less room for inconsistent interpretations between assessors, which hopefully means fewer disputes about methodology. Perhaps we will also see less disputes surrounding PIA assessments in the tribunal when it comes to hearing loss, but there is some discretion involved, clearly about tinnitus, which with mild, moderate versus severe, how severe is it? Are the doctors being more fulsome in their description of prior noise exposure to justify lower frequencies? We'll find out. From a legal predictability standpoint, the IAG3 is positive with more standardisation in place, but there is wriggle room, which is inevitable. Thank you.